Yes.
My lord, may I, with some embarrassment, my lord, mention 103 of the daily list? My lord, this is a section 34 application with a connected application. My lord, are going to have to renew the bank guarantee once again for the fourth time. My lord, that's a security amount. But if your lordship can accommodate us anytime, my lord, whenever it is convenient for your lordship. But otherwise, the matter is not likely to be called on. If it goes on to the monthly list, my lord, again, my lord, we'll not have a turn. Whenever it's convenient, my lord, I know the pressure of the court. I do not insist, but my lord, if your lordship can accommodate us, it will be very good.
34 petition.
Yes, my lord. 34. There is a connected application, but the application is not important. 34 is, my lord, what is the important application?
Let me see.
But there's a point of, my lord, demurrer that will take. I would expect that the matter would not take much time because, my lord, now the point is settled by the Supreme Court. The mandate of the arbitrator, according to us, had terminated.
Let me see.
Very well. Great.
May I handle? For judgment, item number 1, Deepika Ghosh versus Great Island Development Company.
My lord, I am sorry, my lord, I could not appear, my lord, physically just because of, my lord, some waterlogging in my area. My lord, I am appearing for the petitioner in item number 1.
Mr. Jyoti Prakash Chatterjee, advocate, and Rohit Das, advocate, are requested to hold a meeting at the earliest and appoint the presiding arbitrator and thereby constitute the arbitral tribunal for adjudication of the dispute between the parties. All questions relating to arbitrability of the dispute, admissibility of the claim, limitation, and other issues are kept open to be urged before the learned arbitrator.
My lord, grateful, my lord. Only one thing, my lord, before your lordship, my lord, the honorable court directed us to hold a meeting for appointment of arbitrator. If my lord, I heard correctly, my lord.
Yes, accordingly, Mr. Rohit Das is appointed as a nominee arbitrator on behalf of the respondent to adjudicate the dispute.
My lord, grateful, my lord.
2 are already appointed, third they will appoint.
My lord, grateful, my lord.
Commercial list, item number 1.
My application, my lord, for restoration of a section 11 application dismissed for default, my lord kindly has regard to the supplementary affidavit of service. Postal service on 3 separate occasions has come back with the endorsement, no such person,
No such person.
my lord.
Then you have to do a paper publication.
My lord, I am seeking directions for publication. A local newspaper, the respondent, my lord, is located in Haryana, Faridabad.
Affidavit of service taken on record. The service report indicates that the petitioner had attempted service on 3 occasions.
3 occasions, lordship, aside from initially when the restoration was filed.
The endorsement has returned with the remark, no such person stays at the slated address. Slated address. In view of the same, learned counsel for the petitioner prays for a substituted service in this court, directs the petitioner to carry out the substituted service by way of paper publication. Full stop. Uske डाल देना. One in the daily newspaper and one in the overnight. How much time you want?
My lord, 5 weeks since it
No,
is
4.
Haryana.
Just after 6 weeks.
I'm
Number 2. None for the parties. In the interest of justice, adverse orders are deferred. List after 2 weeks.
Item number 3.
Lordship, I appear on behalf of the petitioner praying for not today.
Right? What happened?
My counsel is unwell. He could not reach the
You're
court.
not appearing in item 1, 2, sorry.
No, Your Lordship.
That is also the same,
No, Your Lordship, I am not briefed in that matter.
not today. Item number 4.
Well, I'm for the report.
This is my section 29 application. This is, my lord, the third extension application. My lord, the last extension was granted by an order of 10th December 2024, page 127, my lord, volume 2.
दिखाना भाई. It is only for publication of the award.
My lord, the arguments are ongoing. The claimant is yet to conclude its argument.
Arguments, my lord, for the claimant, my lord, is about to be concluded, my lord, within 2 or 3 hearings. And argument for the respondent would commence, my lord.
When was the arbitrator appointed?
My lord, the first meeting was held, my lord, on 22nd March 2021.
Right then.
My lord,
Completed.
pleadings have been completed, my lord. Statement of claim was filed on 1st July 21, and there was a counterclaim. We have filed our additional SOD to the counterclaim on 29/6/2022. However, my lord, after the mandate was extended for the last time, we have
6 months was extended till
6 months, my lord, was extended till 28th December 2023.
alright. And this court had granted extension.
The first extension, my lord, was granted till 28th June 2024
It was done on 27th.
on 27th February 24.
Then
And the second extension, my lord, was granted on 10th December 2024 till 9th June 2026.
9th June. Where is that 10th of December order?
10th of December order, my lord, is at page 127.
Take up. No objection, right?
No, my lord.
First paragraph. Same. The parties, as per the terms of the contract between them, constituted the arbitral tribunal, and the tribunal held its first meeting on 22nd/3/2021. Full stop. The pleadings were completed on 29/6/2022. With the consent of the parties, the mandate of the arbitral tribunal was extended for 6 months till 28/12/2023. Full stop. Thereafter, this court, by order dated 27/2/2024, extended the mandate by 6 months till 28/6/2024. Stop. In the meanwhile, due to the ill health and subsequent demise of the presiding arbitrator, the parties, by mutual consent, reconstituted the arbitral tribunal. Full stop. Thereafter, this court, by order dated 10/12/2024, extended the mandate of the tribunal by 18 months till 9/6/2026. Learned counsel for the parties submit that the matter is at the stage of final arguments. Full stop. Learned counsel for the how many settings have been done?
Lordship,
counsel for the petitioner states that
56 sittings.
tribunal has held more than 56 sittings. Full stop. Upon consideration, a learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Upon consideration of the materials placed on record and the arguments advanced by the learned counsel for the parties, this court is satisfied that no delay is attributable to the learned sole arbitrator in conducting the arbitral proceedings. Full stop. Having regard to the advanced stage of the arbitral proceedings, and in the interest of justice, the mandate of the learned tribunal is extended further for a period of
My lord, we have prayed for 12 months, your lord.
8 months.
12 months.
8 months from today,
Obligation.
the arbitral tribunal is requested to make all reasonable endeavors to conclude the arbitral proceedings and publish the award within the extended time period. With the aforesaid direction, the present petition stands disposed.
My lord, let it be a joint prayer for 12 months because, my lord, councils, my lord, sometime, my lord, making, my lord, 12 months. It will be concluded, my lord.
12 months.
My application, my lord, 29A. I am seeking extension of mandate of the, my lord, tribunal.
My lord, Wednesday, my lord, I have pointed out to your lordship, my lord, the respondent in this matter, a section 7 application under Insolvency and Bankruptcy Code has been admitted. So
Are you aware of the
I have given a copy of the application, my lord. I don't know the fate of the matter.
if
I made be, my
this
lord,
is
kept in abeyance, my lord, so that let the outcome of the IBC proceeding be over. Suppose their claim is rejected, then I will be in problem.
my lord, the
Kindly, my lord, keep it in
my lord,
abeyance,
the-
my lord, with liberty to, my lord, mention.
my lord, the law is this, my lord, till the section moratorium under section 14 will be subject to what my learned friend says. Till the moratorium under section 14 will be in force, my lord, all proceedings against the company will be stayed,
That's right.
my lord. So
That's what he's saying.
yes,
I'm saying,
my
my lord,
learned friend is saying he doesn't know about the fate of the company.
No, he is. I know.
I am
I got a
saying
copy of petition only. What is the order? Whether the UI has been explained.
So you can see all that.
Yeah,
and
I'm
come
giving a
back.
copy.
I'll see,
Here
my
it
lord.
You come back next week, you have a look at the order, come back
Fine.
next week.
I'll
In the
give it in
meantime,
week's
my lord,
time.
arbitrator is proceeding. I have served a copy upon the arbitrator also. My lord, learned arbitrator is
Him
proceeding.
proceed. He shouldn't proceed.
It will be a nullity, whatever he is.
Absolutely to be a nullity.
Now he has to pass a formal order that they, in view of this IBC proceeding. That's why he has called a meeting on 22nd, not to proceed. So it's call a meeting to consider the order of the,
I would have
IBC.
been, I
Cannot
could have,
proceed.
I could have shown the minutes to your lordship where learned arbitrator has recorded that he will consider the section 7 application. Nonetheless, my lord, we shall inform him once again.
Lord, 1 week, my lord, that will come back with the
I also, my lord, it's my duty to point out my client, the board of my client has carried out an appeal before in National
Flat.
Company Law Appellate Tribunal. So if there is any development in that
No,
matter, my lord, I will inform my lord.
In which matter? Appeal has filed. When admitted, when appeal filed, nothing is everything is suppressed.
Nothing.
I've got a copy of the petition only.
No.
There is
Suppressing anything, sir. He is
am-
saying
no.
he's
He
rather
has gone in appeal also against the order. I don't know the appeal.
being candid. He's saying that.
No, he should supply a copy to me, my lord.
No, that appeal is not handled by me, but I have been informed.
He should
So I-
update me, my lord. Kindly keep it after 1 week, my lord, so that I can come back next Friday,
Next Friday.
my lord.
Lord, I have handed over a copy to my friend. It's a order, sir. আপনাকে অর্ডারটাই দিয়েছি চিঠিতে।
I've got a copy of the order.
His client responsibility also.
My lord, for the respondent, my lord. The counsel appearing for my lord, Mr. Joyce Singupta is appearing in this matter, my lord. He's not in court today, my lord. He's requested for a day's adjournment.
What is this? 29A?
Yes, my lord.
Any objection?
Lord, as a statutory authority, I was only hoping that your lordship will kindly not record my consent. That's all. Otherwise,
Not today.
grateful, my lord.
Give to the respondent.
You're for the
Your Lordship, I'm appearing for the petitioner. I'm praying for not today, Your Lordship.
Why? What happened? Too much rain?
Lordship, sorry, Your Lordship.
Too much rain? What is the difficulty?
Lordship, the counsel appearing in the matter is before a different bench, Your Lordship.
So you can do it? It's a 29A application. Tell me the dates.
Yes, Your Lordship.
You have
Your
any
Lordship,
objection to
the,
We have no objection. Give me the dates. We'll finish it off. Yes.
Your Lordship,
When was the arbitrator appointed?
Well, the arbitrator was appointed by an order dated 22nd December 2023 under the section 9.
Yes.
Now, my lord, the section 21 notice for the first, my lord, there are three references in this case. So for the first reference, my lord, the section 21 notice was sent on 8 January 2024.
completed on
My lord, the preliminary sitting was on 29th February 2024. And my lord, the pleadings were completed by
Two references here.
three references, my lord.
time has not elapsed in the third reference.
My lord, time has not
between the same
elapsed in
party,
the
Your Lordship.
third reference. In the first two references, the time has elapsed, my lord. Now, my lord, in the first reference, the pleading was completed on 4th June 2024, my lord.
Yes. Second reference.
Now, my lord, second reference, the first sitting was on 8th September 2024.
All right.
My lord, the section 21 notice was on 13th August 2024.
Pleadings were completed on
31st December 2024. Now, my lord, in the first reference,
yes.
the mandate had expired on 5th June 2025.
Okay.
Now, my lord, while there was no formal order of extending the mandate, my lord, orally at that time, my lord, the learned arbitrator had indicated it, and we participated in section 17 proceedings after that, my lord, and it stood, in that sense, it stood extended till 5th December 2025, my lord. So, my lord, and the mandate for the second reference expired on 1st Jan 2026, my lord.
Yes.
So, my lord, we are seeking an extension of 1 year, my lord. They are seeking an extension of 1 year, and we have no objection to that, my lord.
So this is for extension of the first mandate, the third mandate.
First and second mandate, my lord.
First and
The
second.
third mandate is existing as on date. It's not, the mandate has not elapsed.
Appointed in May.
For the third, I don't think it's necessary third.
All right, take down. The petition has preferred the present by first factor of same order. This court-wide order dated 22/12/2023 had constituted the arbitral tribunal for adjudication of the dispute between the parties. Full stop. The pleadings in respect of the first reference were completed on 4/6/2024. Full stop. Thereafter, the petition number 2 initiated second arbitration proceeding, and the parties, by mutual reference, referred the second reference to the same arbitral tribunal. Full stop. Full stop. Pleadings in respect of the second reference were completed on 31/12/2024. Full stop. The mandate of the arbitral tribunal qua the first reference was extended till 5/12/2025, and qua the second reference till 1/7/2026. Full stop. Thereafter, the parties jointly initiated a third reference and, by mutual consent, appointed the same arbitral tribunal, while order dated 16/6/2026, the arbitral tribunal issued directions for completion of pleadings therein. Full stop. Learned counsel for the petitioner submits that since the matter is complex and involves multiple references, he prays for an extension of 1 year for the mandate of the arbitral tribunal. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Upon consideration of materials placed on record and the arguments advanced by the counsel for the parties, This court is satisfied that no delay in the conduct of the arbitral proceedings is attributable to the learned arbitral tribunal. Full stop. Given that there are multiple references, comma, with various applications pending and the proceedings overlapping, comma, this court is of the view that it would be in the interest of justice to extend the mandate of the learned tribunal qua the first and second reference for a further period of 1 year from today. Full stop. The arbitral tribunal is requested to conclude the arbitral proceedings and publish the award within the extended time period. With the aforesaid direction, the present petition stands disposed of.
Grateful, Your Lordship.
Lord, I'm appearing for the petition.
Yes.
This affidavit of service. This is section 29A application.
Have been served?
Yes, Your Lordship. And we have also acquired a written communication from the advocate of the respondent that they have no objection to the extension of the mandate of the arbitrator. Your Lordship, this is the second extension which is being sought, Your Lordship,
How have you served them, sir?
through email.
Why not by post?
Your Lordship, that is the usual communication that we do. This arbitration has been going on for quite some time, Your Lordship. And Your Lordship, they have already communicated to us through email also that they have received the petition and they have got no objection. I'll be putting that document on record, Your Lordship.
Where's the document?
Your Lordship, it's on the way, Your Lordship. In the meantime, Your Lordship, if I can take Your Lordship's kind attention to the first meeting for first extension, that is on the page 15 of the application.
Serve them again. Come back. Serve them through post, come back again. Learned counsel for the petitioner speaks and is granted liberty to effect service upon the respondent just after 2 weeks. Affidavit service regarding.
Deeply
Nine.
Lord, may it please your Lordship, Lord. This is an application under section 29A5, Lord.
Yes.
Lord, by an order dated June 27, 2023, the learned arbitrator was appointed at page 21, Lord. First sitting was held on July 26, 2023. By consent of the parties, time was extended for a further period of 6 months.
Yes.
And at page 32, Lord. It will help to your Lordship. By an order dated May 19, 2025, the mandate of the Honorable Arbitrator was extended for a further period of 1 year from the date of the communication of the order. Then the Lord aforesaid order was communicated. Then at the verge of the completion of the argument, Lord, the respondent changed their set of advocates on July 10, 2025. Then they have filed 2 applications. One application under section 27, other 23(3) of the Arbitration and Conciliation Act to stall the process. Subsequently, they adduced, my Lord, n number of they have given n number of decisions, and subsequently, Honorable Arbitrator was compelled to dispose of both the application by rejecting their prayer, by giving 88 pages of judgment. Challenging the propriety of the 2 orders, my Lord, they filed a revisional application. This revisional court of this court, my Lord, did not permit them or grant any stay. But they insisted the Honorable Court asked them to pay liberty before the court so that they can approach before the Honorable Tribunal, seek for an adjournment. On the basis of that order, my Lord, kindly see the order once.
Page,
my Lord, 43.
Yeah.
These two matters was taken up together. Similar issues are involved. Mr. Chaudhary, learned senior advocate appearing on behalf of the petitioner, pressed for an interim order of the stay of the arbitral proceeding on the ground that the certain subsequent events has taken place. On the amendment of the statement of defense was sought for. The said prayer was refused by the learned arbitrator on the ground that the amendment of the pleading could not be allowed after expiry of the 6 months from the completion of the pleading as contemplated under section 23(4) of the Arbitration and Conciliation Act of 1996. It is submitted that the dates have been fixed consecutively over the weekend and for argument, unless the proceeding are stayed, the revisional application will become infructuous. The matter cannot be taken up in absence of such and such because on previous day, Milord, I was not available due to demise of my one of the relatives. The learned advocate of the opposite party, it was informed by Mr. Ganguly, the learned advocate, that there is a bereavement and such and such. Under such circumstances, petitioner is granted liberty to pay an adjournment before the learned arbitrator on the next date fixed argument and list such and such. Then kindly see the communication. Seen the next page 45. Seen the prayer of the adjournment for the further hearing of the present arbitration proceeding filed today on behalf of the respondent and also the order passed by the Honorable Court, Calcutta, today on the revisional application number such and such, CO number such and such. In view of the above, the order passed by the Honorable High Court, the further proceeding of the arbitral proceeding fixed on 6th such and such are adjourned till further order in this regard and may be passed by the Honorable Court such and such. Subsequently, thereafter, no endeavor was made to get the matter listed. I have mentioned the matter, my lord, number of occasions since the honorable business of this court does not permit to take up the matter, my lord, because the maintainability is there, but the consistent stand is, my lord, these revisional applications should not be entertained. But they are keeping the matter pending without, my lord, taking any steps. Kindly see the next order, my lord, 10th of December 2025. Such and such for the opposite parties has argued, because that is, my lord, myself, on the issue and as to why the document and the sought to be tendered by the petitioner were rejected and the learned arbitrator with the details such and such. I am of the view that Mr. Dattu is required to be heard for the further detail for the compliance and the sought to be relied upon such and such and the may be filed before the court on the returnable date. Upon serving the advance copy upon the learned advocate on record of the petitioner. As the learned arbitrator has adjourned the matter till the decision is taken by the court in the revisional application, I do not think that there is any need to pass any further order of the stay of the proceeding. Then subsequently thereafter, matter disappeared.
Not for me to see.
No, my lord. I am showing the conduct of. I am showing the conduct of the DVC. Set up this is.
Don't have any objection. Will extend. Take down. Application filed under section 5. A4, application under A4, right?
A5, 29A5. Yeah, you taking this set of lawyer gulo dekhalo to. দিয়ে দিন।
This court by order dated 27 June 2023 had appointed the sole arbitrator to adjudicate the dispute with the party. The pleadings were completed on 10/1/2023. With the consent of the party, mandate of the arbitral tribunal was extended for 6 months till 15/5/2025. This court by order dated 19th May 2025 further extended the mandate of the tribunal by 1 year.
From the communication of the order, I will not communicate. Till such time that would not be disposed of.
No, 1 year.
1 year from the date of the communication of this order, my lord. Kindly do.
I'm not talking about this one. The tribunal by 1 year. I'm recording the earlier one. The parties were on the verge of concluding final arguments. When at that stage, the respondent filed application under section 27 and 23(3) of the Act respectively. Full stop. The tribunal dismissed both the applications. Full stop. The respondent challenged the said orders before this court and the same are pending adjudication. Full stop. During the said proceedings, this court directed the respondent to seek an adjournment before the learned tribunal. Full stop. Hence, the matter was adjourned and awaiting the direction of this court. Since the mandate of the tribunal expiring on 21/6/2026, the petitioner has preferred the present petition for extension of the mandate of the tribunal. Learned counsel for the respondent states that he has no objection to the present application. Full stop. Upon consideration of the materials placed on record and the argument advanced by the learned counsel for the parties, this court is satisfied that no delay is attributable to the learned sole arbitrator in conducting the proceedings before the arbitral tribunal. Full stop. Having regard to the advanced stage of the arbitration and the interest of justice, the mandate of the arbitral tribunal is further extended for a period of 6 months from today. 6 months?
Make it, my lord. Because I don't know, my lord, when this application would be disposed of. Only 2 days required. Only 2 days required. I have concluded my argument. The DVC will conclude their argument. Only 2 days required. 6th and 7th was fixed. That date has become infructuous since they made an adjournment.
8 months. 8 months. The arbitral tribunal is requested to make or release the matter.
My lord, I have stated everything to show the conduct of the DVC, my lord. Nothing else.
But at the wrong forum.
Yes, yes. My lord, the affidavit service be kept with the record.
Tribunal 10.
My application under section 29A, my lord. This is a second extension, my lord. So
Side.
first, my
Is on the other side.
lord, Mr. Meghojit Mukherjee was appearing. He has been served, my lord.
Service.
The service and notice of motion is on record, my lord. Notice of motion back page, my lord. He has received it.
Have you served the client? Respondent.
Client has not been served, but he is the
Okay.
appearing advocate.
Serve the respondent.
Has
Learned counsel for the petitioner seeks and is granted 2 weeks time to effect service upon the respondent. List after 2. 3 weeks. Please complete the service process.
deep.
Item number 11, Your Lordship, this is an application under section 11 for extension of mandate of the arbitrator. Your Lordship,
29A.
29A4, Your Lordship, I've served on the other side. The mandate would expire on 23rd July of 2026, Your Lordship. We are only asking for the ground, on the ground of, Your Lordship, I'm being led by Mr. Amitesh, sir, whose wife has passed away yesterday, Your Lordship. Kindly keep it on 20th of July, Your Lordship, you would be able to appear on that day.
Proxy counsel so-and-so appears and states that the main arguing counsel has suffered a bereavement in his family. She prays for an adjournment. Let this matter be adjourned. When do you want to give the date?
20th July, Your Lordship. He would be appear.
Otherwise, don't have any objection to the extension.
Oh, if there is no,
There's no objection. If you want, I can allow the application.
if Your Lordship, the other side has no objection, then
Give the date.
objection to extension is हमारे कुछ नहीं तो. Your Lordship, let the notice of motion and service be kept on record.
Mr. Saha, give the dates. Give the date. When was the arbitrator appointed? Madam, give the dates. When was the arbitrator appointed?
Your Lordship, the arbitrator was appointed. Your Lordship, the pleading started on 7th March of 2022, Your Lordship, and that expired on 7th of March 2023. This is, Your Lordship, the third application we are filing for extension of the mandate of this arbitrator, Your Lordship.
Give the sequence.
Okay, Your Lordship, 7th March of 2022, pleadings were completed.
7th.
7th March of 2023, Your Lordship, time period for 1 year expired. Then, Your Lordship, 15th March of 2023, the respondent was approached to give consent for 6 months. The respondent refused. For that, Your Lordship, first application was filed on 18th May of 2023, on the basis of which, Your Lordship, the matter went to Your Lordship, the Supreme Court, where by way of a reported judgment, it was extended till 31st May of 2025. Then, Your
31st May.
Lordship, yes, Your Lordship,
31st May 20.
31st May of 2025, Your Lordship,
Order of the Supreme Court is 12th of September.
12th of September, Your Lordship, is the order of the Supreme Court. And subsequently, there was another order on 23rd October of 2024, Your Lordship, by which award was extended, arbitral tribunal was, it was extended till 31st March of 2025. Then Your Lordship, after Your Lordship, 31st May 2025,
Yes.
Your Lordship, the mandate got expired, and again, Your Lordship, we filed a second application.
Yes.
And Your Lordship, the order extending that mandate, Your Lordship, is at page number 32. That second order, Your Lordship, 21st July 2025. The relevant portion would Your Lordship would find at page number
Paragraph 10.
from 42. Yes, Your Lordship, paragraph 10.
All right, take down. The petitioner preferred the same first paragraph. This court by order dated 28/2/2024.
Your Lordship, page 43. If Your Lordship kindly comes to page 43, paragraph 12. Yes, Your Lordship.
This court
And-
by order dated 28/2/2024 had appointed the sole arbitrator to adjudicate the dispute between the parties. The pleadings were completed on 7/3/2022 after the expiry of 1 year from the date of completion, the respondent refused to extend the mandate of the tribunal. Full stop. Hence, the petitioner approached this court, however, the said petition was dismissed. Full stop. Petitioner challenged the said order before the Honorable Supreme Court, and by order dated 12/9/2024 in SLP number.
Lordship, can I give Your Lordship the reported judgment number?
Yes.
2024 SCC online SC.
SLP number.
Oh, SLP number, Your Lordship, would be SLP Civil 23320 of 2023. 23320 of 2023.
23320 of 2023 was allowed. Full stop. In the said proceeding, the Honorable Supreme Court extended the mandate till 31/5/2025 and directed the parties to approach this court for any further extension if required. Full stop. Thereafter, this court, by order dated 21/7/2025, extended the mandate by 1 year. Full stop. Learned counsel for the parties state that the matter is the stage of evidence. Full stop. Learned counsel for the respondent states that he has no objection to the present application. Full stop. Upon consideration of the materials placed on record and the argument advanced by the learned counsel for the parties, this court is satisfied that no delay in the conduct of the arbitral proceedings is attributable to the learned sole arbitrator. Full stop. Having regard to the advanced stage of the arbitration and the interest of justice, the mandate of the arbitral tribunal is further extended for a period of some time.
A year, Your Lordship, because the respondent.
Second witness is on stand. There are 1 year from today. Full stop. The arbitral tribunal is requested to make all necessary endeavors to complete the arbitral proceedings and publish
Your Lordship, one indulgence.
extended time period.
The SLP, Your Lordship, was later on taken up in the civil appeal. So, if Your Lordship would include the civil appeal number, that would make some relevance. Your Lordship, kindly come to page number 28. It will be evident for Your Lordship. The civil appeal number is 10620 of 2024.
This is the order of 29th. What is the date of this order?
The date of this Supreme Court order, Your Lordship, is 23rd October.
Give me the order of 12th of September
Just
2024. Where's the order of 12th of September?
12 September, your lordship, is at page number 9. In that order, also in a bunch of the first, civil appeals 10620 of 2024. আমাদের তো 10620 2024.
This is civil appeal number 10620 of 2024, not the one you gave me.
That is your lordship, the SLP. SLP was then changed to civil appeal.
तो वो कर दो in क्या लिखा है उसका while audited so and so allowed in civil appeal number 10620 of 2024.
Grateful, your lordship.
May I please your lordship, Lord? Lord, I am appearing in item number 12, my lord. This is a petition which is filed under section 9 of the arbitration law.
Colleague begins, sir. I'm for prison. May I request my learned colleague to kindly indicate to your lordship where is the arbitration clause? I didn't find in the text.
Where's the arbitration clause?
Yes, my lord. The arbitration clause, my lord, is contained in both LOI as well as the work order, which is there, my lord. The work order, my lord, is at page number 353.
That is the LOA, and next page is the work order, 354.
353 and 354, my lord. 353 and 354. 353 is the LOI, and page number 354 is the work order, my lord. Annexure E, page 354, my lord. Third unnumbered paragraph, my lord. The contract, my lords are there. Third unnumbered paragraph. The contract and the parties therein shall be governed under the jurisdiction of Calcutta High Court for resolution of dispute through arbitration, if any.
With deepest respect, this is not an arbitration. If this is the only arbitration clause.
It is the arbitration clause, my lord. And my lord, in the LOI as well, just one page, and that at 353, my lord, will see at paragraph 4. LOI concludes the legally binding document between you and BNDR till the issue of work order contract. The work order and the parties therein shall be governed under the jurisdiction of the Calcutta High Court for resolution of disputes through arbitration, if any. So, my lord, the jurisdiction, exclusive jurisdiction, my lord, is conferred on this honorable, this honorable court, as well as, my lord, for the purpose of arbitration. This is the jurisdiction which has been conferred under the agreement between the parties. Though not happily worded, my lord, I must say it should have been detailed, but this is the document which is from their side, my lord. This is the document that they have generated, but there is an arbitration clause. So, my lord,
can make this issue, I can argue the point of maintainability after my learned friend finishes on merit. On merit, I have only one thing to say. Is an application for restraint order to invoke a bank guarantee. There is a letter, date of a letter given by which they think that I am going to invoke bank guarantee. Bridge and Look is not going to invoke bank guarantee by that. So I am making this task easier.
They are
so,
not.
my lord, I don't need to say anything else, my lord. My learned friend statement may be recorded, and then I will invoke the arbitration mechanism, my lord, and I'll fight this on merit.
Arbitration, my lord, is not the chosen forum between the parties. I have been carrying.
My lord, that is an objection, my lord, in my respectful submission.
If that is the objection, then this petition is not maintainable.
No, my lord, then I will satisfy your lordships on maintainability, my lord. There is no problem, but my learned friend statement may kindly be recorded to that effect, and then, my lord, I'll say.
Mr.
Samir, my lord.
Mr. Samir, this statement can only be recorded if the petition is maintainable. If it is not maintainable, there is no question of recording any statement.
All right, my lord, then I'll satisfy your lordships on the maintainability, my lord.
Yes.
So the issue is of maintainability then, my lord. My lord, in the work order which has been issued, my lord,
let him address on the maintainability point, since he is raising the maintainability issue.
Sure, yes, my lord. Yes, my lord.
Let him raise his objection, then you satisfy.
Right.
Yes, my lord. Oblige, my lord.
Page 354,
yes,
which is the work order.
Yes.
Lordship will find, my lord,
the only place where the word arbitration
Yes.
is mentioned
Yes.
is the second paragraph.
Yes.
The third paragraph. The
Third paragraph.
contract and the parties therein shall be governed under the jurisdiction of Calcutta High Court. I pause over here. So no dispute, Calcutta High Court shall have exclusive jurisdiction for resolution of dispute through arbitration, if any. So, my lord, naturally, it indicates that if there is any dispute, then Calcutta High Court will have jurisdiction for resolution of dispute through arbitration. Now, my lord, kindly comes to the next page. This is not the work order. This is a covering letter to a work order. That created confusion in my mind. My lord, will kindly come to the next page.
Yes.
And see the last, the paragraph, the first paragraph it would be. We are sending here with 2 copies, including original of the work order or contract only, as the other documents forming the integral part of the work order or contract has been
Issued.
I hope your lordship
Issued.
wishes,
Yes.
Lord,
Issued to and accepted.
issued to and accepted by you, and would request you to return to us duplicate copy of the same, duly signed and stamped by you, in token of your unequivocal acceptance at the earliest. Lordship is completely aware under section 7. An arbitration agreement has to be signed. Now, of course, it can be communicated by email, facsimile, etc. But, my lord, a contract ipso facto may not be signed. Conduct may show that there is a contract. I accept there is a. But, my lord, what has to be shown to your lordship today is that the arbitration agreement, being an exclusive contract by itself, was signed and returned or exchanged between the parties. Certainly, my lord, this is not the page where the arbitration agreement exists. So the paragraph in the middle, my lord, of the first page 354 envisages that there is going to be a work order which may contain an arbitration agreement. This, my lord, I was, my lord, in an inquiry, I asked my client whether there is, my lord, a separate work order or not, because the notice inviting tender doesn't have any such arbitration agreement. And even if, for argument's sake, we believe that there might be, that would still, my lord, entail to the disputes at the notice inviting stage. So today, my lord, I am unable to find any clause or agreement where parties, my lord, have mutually agreed to resolve their disputes through arbitration, because that ad idem stage or ad idem status has to be shown to your lordship. But this is the only thing which I had to show to your lordship, my lord, on the small issue of maintainability. And, my lord, may I hand up to your lordship, my lord?
But if you read the last line,
yes,
this letter along with the LOI and the NIT shall only form this contract, and all other letters exchanged.
Yes.
And
So, my lord, your lordship,
and on the previous,
what are the other ones?
On
And
the-
it comes to the first page, a list is there.
if you see 353, that is the letter of intent. The letter of intent itself again talks about the arbitration clause.
No, it's in the
resolution of-
same way.
That's
The
right.
point is that, my lord, it's in the same way.
Right.
It's in the same way. My lord, what? That's why I said, I never said that there is no arbitration clause. I just requested my learned friend whether there is a work order which they have disclosed or not. My lord, I have also made the same inquiry to Bridge and Group.
So letter of intent is there.
Yes, my lord.
All right. This letter is there.
No, my lord, there has to be an arbitration agreement.
But this is how it has been worded here. This is your document. That the dispute will be resolved through arbitration.
But this is exactly, but this, my lord, doesn't seem to be a sufficient clause to indicate that parties, my lord,
Then
will
that you
redress their disputes to arbitration. It also says that there should be a contract. So I inquired to my learned colleague, my lord, here whether there is a work order separately or not, or is it just these 3 pages of document, because it doesn't show any arbitration agreement. And my lord, I haven't stopped over there. On merits, I have already given him my assurance.
Oh, that's right. But on the merit, then if I record
The
the
issue over
submission,
here, my lord, is that today,
then
your lordship,
I'm admitting section 9.
then, my lord, we are also admitting that there is an arbitration. But as it appears from records, my lord, there may not be an arbitration clause. So I, my lord, wanted to rely on the Supreme Court decision.
Yes.
This is, my lord, one of the recent ones.
Yeah.
Well, it's a judgment of Nagarika Indicon Products Private Limited versus Cargo Care Logistics, reportable, my lord, an order passed by the Honorable Supreme Court on 17th April 2026. Lordship, my lord, will kindly have a look at paragraph 3. What was the arbitration clause which fell for consideration before the Honorable Court? Your Lordship will find that, my lord, at page 3. Page numbers are at the bottom of the page. So, my lord, here the arbitration clause reads, which fell for consideration, the contract evaluated hereby or contained herein shall be governed by and construed according to Indian law. So, the word shall was used not with respect to Indian law. Any difference or opinion or dispute thereunder can be settled by arbitration in India or a place mutually agreed with each other, appointing an arbitrator. Now, my lord, kindly have a look at paragraph 9. The sum and substance of the appellant's case. I'm sorry, my lord, paragraph 6 is my issue. Paragraph 6.1, I'm sorry. May I please, my lord? As commercial transactions grow to involve more and more moving parts, naturally resulting in heightened complexity, time has been a prized commodity and possession. To that end, alternate dispute resolution mechanism have deservedly become the preferred medium, overcoming the otherwise common factors of delay, cost, and also its openness to public, which can have detrimental effect on the commercial value of the dispute. It has become a preferred medium while keeping in most essential factor at the forefront, that is party autonomy or its inherently voluntary characteristics. The concurring opinion, and now Millard, Cox and Kings is referred to, succinctly captures the sine qua non for arbitral proceedings. The parties must mutually intend to refer their difference to arbitration, as consent is the source of the arbitral tribunal's jurisdiction over them. I'm relying on this quote. Now, if your Lordship will kindly have a look at paragraph 9. The sum and substance of the appellant's case is that clause 25 reproduced supra constitutes a binding arbitration clause. In furtherance of this position, reliance has been placed on various decisions. Eastern Coalfields was cited. It has been observed that section heading or a marginal note can be relied on to clear any doubt or ambiguity. In that case, interpretation was regarding a mandatory arbitration clause, but the dispute was as to upon whom the said arbitration clause applies. Having regard to the heading of this section, it was held that arbitration clause would apply only to disputes between public sector enterprises, government departments, and would not apply to any dispute involving a private party. In the present case, there is no such distinction or dispute. The heading uses only one word, arbitration, but as opposed to the case referred to, the model here is can, indicating a choice available to the parties. Here, your Lordship has not found any heading. 9.2. Now, Rajendram Kun judgment is also referred, which has been relied upon by the appellant to submit that a pragmatic approach should be taken, observes that when an arbitration agreement, apart from using the word arbitration or arbitrator, spells out, so apart from, spells out its clear intention by the use of the word shall, its mandatory nature is clear. It has been also observed that deficiency of words and agreement which otherwise fortifies the intention cannot delegitimize the arbitration clause, as is obvious the intention of the parties is anything but clear in the present case. This latter aspect will be elucidated with more clarity in the succeeding paragraphs of this judgment. Now, Visa International was also referred to. And the portion in the middle, which begins with while holding that a binding arbitration clause exists, the court held that one or two words being absent is not the deciding factor. And in fact, it is the whole clause providing for settlement of disputes that are to be seen together to gather the intention of the parties. There can be no qualms with this position regarding the arbitration clause in this case. It can in no way be said that the intent of the parties is clear. This is on two counts. One, the use of the word can, and second, providing for the incomplete procedure regarding appointment of arbitrators, if at all. In Enercon, the question involved, amongst others, not relevant to the present dispute, was regarding an arbitration clause being rendered unworkable on account of the fact that it did not provide the manner in which the third arbitrator would be appointed. Note, I'm not toiling your lordship through Enercon. Now, my lord, in this manner, 9.5, my lord, the opposing contention of the parties were that when the clause for dispute settlement says arbitration or the court, which one would prevail? The court here held that an opinion was available to the parties and the one who invoked the dispute settlement process chose to go for arbitration as such. With that being an option available to him, no fault could be found with that choice. The word used in the clause was should, which is consistent with the fact that an option has been provided to the party. The facts of this case, as it appears to us, are in no way similar to the present case. Now, then with that Rolia, which is most important, the court observed that when there is a doubt, the matter be referred to arbitration. It has also been observed that in matters of purely commercial nature, a liberal approach should be adopted as a one-stop dispute resolution process would be favorable. Once again, these observations are such that no question can be raised against them. The doubt referred to here arises in the construction of the arbitration clause, which is vaguely worded or tight or like. The question of construction, however, only arises when the parties are ad idem as to arbitration, despite the dispute before us being purely of a commercial nature. It is the parties themselves that cannot agree on arbitration being the chosen medium. When that is the case, it is not for a court to compulsorily send parties before the jurisdiction that they have not chosen. Now, Millard will kindly have a look at paragraph 13. Millard, may I please paragraph 13?
Yes.
Turning to the words used in clause 25, we find it to stipulate to the effect that if there is any dispute between the parties, they can settle the same by arbitration. In view of Jagdish Chandra, which holds as under, but mere use of the word arbitration or arbitrator in a clause will not make it an arbitration agreement. If it requires or contemplates a further or fresh consent of the parties for reference to arbitration. For example, use of words such as parties can, if they so desire, refer their disputes to arbitration, or in the event of any dispute, the parties may also agree to refer the same to arbitration, or if any dispute arises between the parties, they should consider settlement by arbitration. In a clause relating to settlement of disputes, indicate that clause is not intended to be an arbitration agreement. Similarly, a clause which states that if the parties so decide, the dispute shall be referred to arbitration, or any dispute between parties, if they so agree, shall be referred to arbitration, is not an arbitration agreement. Such clauses merely indicate a desire or hope to have the dispute settled by arbitration, or a tentative arrangement to explore arbitration as a mode of settlement if and when a dispute arises. Such clauses require the parties to arrive at a further agreement to go to arbitration as and when the dispute arises. Any agreement or clause in an agreement requiring or contemplating a future consent or consensus before a reference to arbitration is not an arbitration agreement, but an agreement to enter into an arbitration agreement. But ultimately, the matter was dismissed. Now, if your lordship, my lord, after having a view of this judgment, comes back to the arbitration clause,
yes,
at the work order, it's the same. At the
both are same.
intent and work order, words are same. The may I read it out once?
Yes.
The contract and the parties therein shall be governed under the jurisdiction of Calcutta High Court for resolution of disputes through arbitration, if any. So, my lord, with deepest respect, Jagdish Chandra's case, my lord, was followed in the subsequent judgment, which I had shown your lordship, my lord. Here, my lord, it doesn't show with deepest respect that there is an intention or parties are ad idem. Now, my lord, this is with respect to the issue of maintainability. Now, my lord, where is my difficulty? The lordship will understand that
bridge and route, my lord, is a government enterprise. But if it is a private party, we can sometimes push ourselves and tell that please, this is you. If there is dispute, there may be dispute in future, accept arbitration. But here, my lord, I am in a difficult situation because if one is accepted and they have, but it's very common because every clause which they have, my lord,
But this is your document, you should not have these kind of.
my lord, that's the reason why, my lord, I have already spoken yesterday. I've spoken to my advocate on record that where is the contract? Because the contract doesn't seem to have been annexed to the application. My lord. My learned friend may not have the contract as well.
Why?
Because he says, now your lordship kindly comes to.
So you're working on the LOI. Is there any contract? Any further
No.
contract?
No, Milord, please see what the NIT, Milord, I have annexed the NIT, I have annexed all the relevant clauses because what is work order ultimately? It is LOI, work order plus NIT. Milord, read paragraph 4, unnumbered paragraph 4 of the work order. This letter along with LOI and NIT shall form this contract. And Milord, my learned friend, paragraph 5, the next page, Milord, at 355.
All right,
read-
Mr. Samir, as
Yes,
far
Milord.
as this clause is concerned, this is not an arbitration clause.
Milord, may I try to
Maintainability.
persuade your lordship, not on this count?
Yes.
May I, Milord?
Yes.
May I, Milord? Yes, Milord.
Yes.
So, Milord, so far as the existence of an arbitration clause is concerned, Milord,
Yes.
the moment the parties between themselves exchange a letter,
Yes.
and they agree that the disputes will be referred to arbitration, it is an arbitration clause. The fact that merely that the clause is not fully detailed will not stifle the agreement between the two parties. Why, my lord? Section 10 of the Arbitration Act says, my lord, the parties are free to determine a number of arbitrators, for example. And then section 10, subsection 2 of the Arbitration Act says, if the parties have not agreed to the number of arbitrators, then in that event, it shall be a sole arbitrator. So, my lord, in section 11 also, if the parties have not agreed to the procedure is prescribed as section 11 will follow. I can go to the court and seek an appointment from this honorable court under section 11 so far as the sole arbitrator is concerned. So, the factor, my lord, my learned friend's client, in not in one place. I can understand somebody by mistake writes the word arbitration as he says, my lord, in one document. No. The arbitration specifically has been referred to, and my lord, the arbitration jurisdiction has specifically been conferred on this honorable High Court by agreement between the two parties. And not the issue doesn't stop here. The letter which I am relying on, the work order which contains the arbitration clause, specifically says that this LOI as well as the work order will form part of the contract, my lord. My lord, I ask a question to myself, my lord, if arbitration is to be agreed, my lord, if I agree in the work order itself, my lord, what else would constitute the arbitration clause, my lord, in my humble submission, my lord. My lord, may I kindly, my lord, and section 7, my lord, of the Arbitration Act, my lord, it says what can constitute an arbitration agreement, my lord. And it can be oral, it can be in writing, my lord. In this particular case, my lord, it is in writing, my lord. May have two provisions, my lord, three provisions, in fact, 7, 10, and 11, my lord. May I read section 7 of the Arbitration Act, my lord?
Yes.
In this part, the arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of the defined legal relationship, whether contractual or not. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. An arbitration agreement shall be in writing. An arbitration agreement is in writing if it is contained in a document signed by the parties. B is the most important, my lord. An exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means, which provide a record of the agreement. An exchange of statement of claim or defense in which the existence of the arbitration clause alleged by one party is not denied by the other. Reference in a contract to a document containing an arbitration clause. So, my lord, I am relying on section 7, subsection 4, and then 4B, my lord. So, my lord, I ask a question to myself. It is the document which is generated by my learned friend's client. It is not an ordinary document. It is the very document by which my contractual relationship with them comes into existence. So, at the first instance in the LOI and second instance in the work order itself, my lord. So, my lord, that is what section 7(4)(b) would squarely apply in this case. That's my humble submission, my lord. And my lord, may kindly have section 10 for a moment, my lord.
Yes.
number of arbitrators. My lord, I understand it is not fully detailed as it ought to have been, but so far as the intention of the parties, so far as the intention of my employer is concerned, is unequivocally expressed that all disputes will be referred to arbitration, and so far as the issue of arbitration is concerned, you will have only jurisdiction will be of the Honorable High Court of Calcutta, and that is why the Section 9 is filed before this Honorable High Court. My lord, may kindly have Section 10. Number of arbitrators. The parties are free. The statutory mechanism is such, if the parties have even said that we agree to arbitration and stop there, then the mechanism is provided in Section 10 and 11, my lord. Section 10. The parties are free to determine the number of arbitrators provided that such number shall not be an even number. Then second, my lord, failing the determination referred to in subsection 1, the arbitral tribunal shall consist of a sole arbitrator. So, my lord, in this case, the number of arbitrators not mentioned. Therefore, section 10, subsection 2 will apply, my lord. And, my lord, if then in that event, my lord, how will I go? Section 11 provides how an arbitration tribunal would be constituted. A person of any nationality may be appointed. 11.6, I can approach this honorable court under 11.6 and seek indulgence of this honorable court to appoint a sole arbitrator, my lord, under section 6, subsection 6, my lord, section 11, subsection 6. Where subsection 6, my lord.
Yes.
5 and 6, my lord, both. Failing an agreement referred to in subsection 2 in an arbitration with a sole arbitrator, if the parties fail to agree on the arbitrator within 30 days from the receipt of the request by one party from the other party to the other to so agree, the appointment shall be made upon request of a party by the Supreme Court, or as the case may be, High Court or any person or institution designated by such court. So, my lord, section 7, 4b, section 10, 2, section 11, subsection 5. My lord, this is the statutory framework, my lord would appreciate this. In a contract, my lord, where a statutory framework is already provided, in a contract, I need not agree on specific details. If I agree on specific details as permissible under the statute, then the contract.
This is not a arbitration clause at all. You can't treat it as
May I kindly reread it, my lord, in the context of this?
Intention of the parties are not here. The mode and method is not here. There's nothing.
My lord, may I reread these two provisions, my lord? I'll just take 5 more minutes, my lord. Page number 353, my lord. In the background of section 7.4b, in the background of section 10.2, section 11.1, and section 11 and subsection 5. And 16 also, my lord, those issues can be raised there as well. Now, my lord, may kindly see 353, my lord. This is letter of intent for works contract in connection with engaging associate of balance system project for development of design, so and so for 3 years. This is the letter of intent. Dear sir, madam, please note that said work is exclusively under works and work contract, and work contract are not governed under the public procurement policy.
Just a minute. Wait a minute. Just read the clause. On
yes,
page 53, just read it. This LOI. All right.
This LOI concludes.
This LOI concludes the legally binding document between you and BNDR.
Yes, Lord.
Till issue of a work order contract. All right.
Absolutely.
Culminate into a work order contract.
Absolutely, Lord.
It reads the work order contract, which is still not executed, which will come into force, and the parties therein shall be governed under the jurisdiction of Calcutta High Court for resolution of dispute through arbitration.
Yes,
so
Lord.
How can you foresee a contract which has not even entered into will have an arbitration clause? Where is that contract?
I bow down, my lord. I bow down, my lord.
This LOI, if it would have written that any dispute arising out of the LOI will be referred to arbitration, I can still understand that. You are saying the work order and the parties therein shall be governed under the jurisdiction of High Court for resolution of dispute. So the work order which is anticipated and which is going to come into existence will have an arbitration clause, and you'll be bound by that. That is what the clause says.
I bow down, my lord. I wanted to
read it. I read the clause.
Well, I will also read it in that context only, my lord. This is the effect of the LOI, my lord.
I can say that the LOI itself doesn't have any arbitration clause. A document which was subsequently or in future to be executed would have contained an arbitration clause, and the parties were supposed to be bound in that contract which has never been executed. So today you don't have any arbitration clause as far as your LOI and work order is concerned.
My lord, no, my lord, may in respectful submission, my lord, may kindly have page 354, my lord.
Yes.
354, my lord, will see, this is work order reference number right at the top, work order reference number so and so, so and so, so and so, so and so, dated 18th of March 2026, which is issued by, my lord, Bridge and Roof Corporation India to GHV India. I am the petitioner, GHV India. My lord will kindly see 1, 2, and 3, the unnumbered paragraph 3, my lord. The contract and the parties therein shall be governed under the jurisdiction of Calcutta High Court for resolution of disputes through arbitration, if any. So only mechanism which is provided in the work order itself. This is the document, my lord.
This is
Now,
a letter.
please see.
Sir, this is a letter. You please see page 2. We are sending herewith 2 copies, including original of the work order, contract only, as the other documents forming the integral part of the contract has already been issued to and accepted by you, and would request you to return us the duplicate copy so and so. So this is, we can't even say that this is the work order.
No.
There has to be, this is
My
a
lord,
letter
my lord.
forwarding the work order. Where's the work order?
Yes, my lord. My lord, kindly see unnumbered paragraph 4, my lord. Just below that. This letter, along with LOI and NIT shall only form this contract, and all other letters, exchange and discussions held with you prior to the date of the issue of this contract shall be treated as unconditionally withdrawn by you. So, my lord, what will be the contract, my lord? Only the LOI as well as this letter. Now, what happens, my lord? Please see, my lord. Please see, my lord, the bottom of 355.
No, sir, you have again, Mr. Samir, you have again read it wrong. This letter along with LOI and NIT shall only form this contract and all other.
Contract.
Yes. So this is the letter. The letter cannot have an arbitration clause and you can't be bound by this.
No, my lord, in my respectful submission, my lord, section 7 I read, my lord. The arbitration can also be in the communications exchange between the parties. This is not just the communication. This is the letter by which the work was awarded to me. So the paragraph number 4, my lord, says this letter along with LOI will form part of this contract. The contract is, my lord, the contract between us with respect to this work. This is the very same contract.
We'll decide.
And, my lord,
we'll decide the maintainability first. Let him
And
file his
one-
reply.
yeah,
Let
my
him
lord,
file
one
his
more.
reply to the maintainability. We'll decide that.
And one more point, my lord, I wanted to raise. Please see 355, unnumbered paragraph 1. The way that my learned friend read, I read it a little differently because he omitted certain words, my lord, while reading it. We are sending here with 2 copies, including original of this work order. Please note this work order. And the other documents forming integral part of this order / contract had already been issued to and accepted by you, and would request to return to this duplicate copy of the same. Same means what? This letter, and stamped by you in token of your unequivocal acceptance. So what do I do in return, my lord? Please see, it is signed by GHV India Private Limited, stamped and signed, my lord. And it is signed by M. Tiwari, General Manager, my lord. So this original is sent, this original is returned, and then please see, my lord, the stamp of my lord, the respondent, my lord, Bridge and Roof Corporation at the bottom where annexure A is mentioned. So, my lord, this letter is sent to me. I accept this letter. This is the basis on which my contractual relationship with them begins. And this mother document, my lord, contains the arbitration, my lord.
All right, let him file his reply. We'll see that.
In the meantime, my lord, his statement to that effect may kindly be recorded so that I am protected.
Oh, that is my. I just
let him.
These are words
let
that
us
told my
see the
learned friend so that
maintainability
he is not
first.
in tension.
Lord, subject to maintainability, my lord, the statement to that effect that my learned friend made at the bar, my lord, may kindly be recorded, my lord, subject to maintainability.
He has made it with responsibility and he'll follow it. The petitioner has preferred the present petition under Section 9 of the Arbitration Conciliation Act 1996, seeking inter alia an order restraining the respondent from invoking / encashing the security cum performance bank guarantee / surety bond dated 14th March 2026, furnished by the petitioner in connection with the execution of the balance of system BOS package for a 100 megawatt solar power project at Khandwa, Gujarat. First off, the case of the petitioner is that pursuant to a letter of intent dated 28th October 2025, and a work order dated 18th March 2026 issued by the respondent. The petitioner was awarded the subject work valued at 1,1954,04299.96 excluding GST. Full stop. In terms of the contractual requirement, the petitioner furnished a security cum performance bank guarantee / surety bond bearing number 12 hyphen 6621 hyphen 000864109 for a sum of 583,38371 through Bajaj General Insurance Limited, valid till 24th October 2027. Full stop. At the outset, learned counsel for the respondent states that the present petition is not maintainable under Section 9 of the Arbitration and Conciliation Act. He states that the arbitration clause as contained in the work order and the letter LOI is not an arbitration clause strictly in terms of the Arbitration Act. Full stop. He states that the intent of the parties to arbitrate is not reflected from the clause which is relied upon by the petitioner to maintain the present petition. Full stop. He seeks and is granted 2 weeks time to file his affidavit in opposition, reply to the same if any within 1 week, list after 4 weeks.
Lords, may I file the notice of
Lord, I
motion?
I seek liberty, Lord, to file an affidavit, additional affidavit, my Lord, bringing on record this surety bond, my Lord, insurance bond.
Learned counsel for the petitioner seeks and is granted liberty to bring on record the performance cum guarantee.
So bank guarantee is annexed already.
It's already there.
No, Lord, it is letter by which it was placed, no, detailed terms and conditions are not there. I wanted to place that on record.
Detailed terms and conditions of the bank guarantee.
It is surety insurance bond, my Lord.
Surety insurance bond.
Obliged, my Lord.
I'm deep up.
Alert, I am appearing in this way.
I appear for the response number 1.
Yes.
My lord, my humble submission is that at the very outset, I should inform this honorable court that, my lord, one important document and fact has been missed out in the petition.
Then you
That's why
take that important document and whatever has been missed out by a supplementary affidavit.
please, my lord.
What have you missed out?
My lord, actually, my lord, before this Section 9 petition, one Section 9 petition has been filed in 2025. Though relief has been granted to the petitioner, but subsequently that petition has been dismissed in default. My lord, though this is a separate cause of action because now there is a separate demand and now they invoke bank guarantee, my lord. So this is a separate cause of action, but I should be fair to this honorable court. That's why, my lord, while reading the brief, I got to know that this particular fact has been missed out. So, my lord, that's why I'm at the outset, I want to concede this fact.
Yes.
No, if I may just point out one thing, as my learned friend pointed out, this, his petition revolves, primarily around the bank guarantee, which had been invoked, payment has been made, I'm told my instruction bank guarantees have been returned. That being the case, his prayer would be instructed.
Bank guarantee has already been returned.
My lord, now, my lord, when we filed the petition, bank guarantee was not in cash.
So,
But, my lord,
sir,
yesterday,
today it has been returned. So this petition has become infructuous.
no, my lord. My lord, there are 3 prayers. My lord, kindly see my prayer. It's not only for bank guarantee because, my lord, I am doing their regular work. So, my lord, they may deduct any of my payment. So
Very
that's
good.
why, my
They
lord,
can. They can.
I'll deal with those if my lord wishes to, but my submission is if you wish to take the prayer for bank guarantee, that is not a prayer.
Bank guarantee is only one prayer.
That prayer, my lord, instructions in time.
My lord, kindly see, my lord, prayer A, an order thereby restraining respondent number 1 or
I will
any
not
of its
allow to, if you have filed a section 9 before and you have not divulged that information in this.
It's subsequent to the file.
No, he has filed a section earlier also.
Yes.
Which he has not.
My lord, I thought my lord was talking about the
No,
bank.
he has not
I have
divulged
not-
that.
Yes, indeed.
You withdraw this petition, file a better petition with better particulars.
My lord, then give me liberty to withdraw it with liberty to file a fresh.
Learned counsel for
Oh,
the
my
petition.
lord, I have one submission if my learned counsel will agree. My lord may appoint one arbitrator. I will file section 17 instead of section 9.
No, he is not agreeing. Learned counsel for the petitioner seeks to withdraw the present petition with liberty to file appropriate proceedings in accordance with law. The present petition is dismissed as withdrawn. Liberty as prayed for is granted.
Highly grateful.
I'm grateful.
If my lord may observe, because sometimes they will not say that we concealed material fact from this honorable court, because my lord, at the very outside, I on my own informed this honorable court. So my lord, if observe this line, because they may in future.
I don't need to observe anything, sir. I have already
My
granted
lord,
liberty.
highly grateful. Highly grateful.
Madam 14. My lord, I seek for an adjournment. My lord, my senior is very sick and he could not be in court today. I have to leave for a week as he is down with serious illness.
Same ground has been.
Same ground.
No, my lord, my senior really
Who's your
wanted to
senior?
be here today. He'll definitely be there.
Who's your senior?
Mr. Udvan Bhattacharya.
He was here yesterday.
No, he's really fallen sick. He's under the weather. In 1 week, we'll be absolutely ready.
Proxy counsel. Subha Pathak.
Yes, sir.
What's your name? Pathak? Siddharth Banerjee. Siddharth Banerjee appears for the petitioner and states that the main arguing counsel, Mr. Rudraman Bhattacharya, who was in court, has fallen sick and has left for home. He prays for an adjournment. Let this matter be adjourned to
Wednesday. Grateful, man.
May it please your lordship, my lord. Items 15 and 16, my lord, my applications, my lord.
If we allow 9, then your 16 goes. Then, if we allow section 11.
11, then the 9 goes, yes. And we can go and agitate everything before the learned arbitrator to be appointed.
Mr. Thakkar.
Yes, I have raised the preliminary objection that there is no arbitration agreement in existence between the parties. That was sought to be because, and the contention is twofold. If your lordship takes the 11 once, please.
May I just indicate on the last occasion also, my lord, the point taken by Mr. Thakkar is that the business transfer agreement has a reference to a particular contract number. And that contract number, my lord, is not reflected in the agreement between the parties. Now, we had indicated before your lordship, my lord, that we maintain 2 sets of numbers. One is a reference number and one is a contract number. And we had also handed over a copy of an email showing, my lord, that we had sent an email to them which had both these numbers mentioned in that email. So they are very well aware that the document or the contract being spoken of is the very same document. There is only one contract. And we have also subsequently obtained further documents and further correspondence between the parties, which will also make it clear that they are at all points of time aware that this particular contract has A, a contract number, and B, a reference number. So there's only one contract. And moreover, my lord, before Mr. Thakkar takes his further points, my lord, we've also examined our documents in detail, and we find that in their balance sheet, my lord, there is a clear reference to, my lord, Shrey Equipment Finance Limited, which is, my lord, the company to whom this business was transferred to. They accept Shrey Equipment Finance Limited as the company to whom the debt is due and payable to. Now, having said all this, perhaps, my lord, it would not fall in Mr. Thakkar's mouth to say that there is no arbitration agreement between the two of them, but I leave him to make his submissions. And I'll also indicate, my lord, what they have also done recently is they filed a vacating application, which is also listed before your lordship. That is IA number 1 of 2026, which is part of item 16. My submission would be all these points can go before the arbitrator.
The prima facie state that there is no arbitration. That is the case. Prima facie satisfaction, there is no arbitration agreement in existence. Kindly have the document. If that was a single piece of paper which was handed over to your lordship. There was no email, there was no affidavit. Yeah. Yeah. This is what was given to us. There is no email to this. It's by SIFL. And it has a contract number 1157. So two things. A, it is not issued by the petitioner before your lordship. It is issued by SIFL, the other company. Second, kindly have, I have stated on oath in my vacating application that I have never received this document. It requires my confirmation. Can you come to the next page, the second page of this document? It requires the confirmation of the borrower. There is no such confirmation. And and since this was a subsequent document disclosed in course of hearing, I filed an application in the section 9 for vacating the order, the ad interim order which was granted, stating that I have never received this document. And what is more important is this matter that I have stated that even after the so-called date of transfer under the business transfer agreement, they say that we had a business transfer agreement, that date of transfer. After that date of transfer, I have made payments to SIFL, not SCFL, which has been received by them. If the loan had been assigned, as they claim, that this is the loan, and this loan and agreement are one and the same, and if the loan had been assigned, then there is no way as to how SIFL could have received it. And I've given particulars, the check details as to how payments. And all the submissions which are now being made across the bar, there's nothing on oath to say this. It is only when I came and took this point before your lordship that this document was handed across the bar to show that no, this is a valid assignment. But the documents disclosed as on oath by them don't show this number anywhere. Now, I want to buttress this fact by taking your lordship to the documents which they have disclosed. None of the documents which they have disclosed, apart from this scrap of paper which is not on oath, have reference to this number 1157. Kindly see the application which they filed before the NCLT. Because that shows that is on the basis of the same debt, no reference to this number. And that is on record. Kindly see the NCLT application which they filed along with the section 9.
We have not asked for affidavits, huh? In section 11.
They've not.
This point we can put it on affidavits. There's no difficulty. I am only suffering that order of injunction. That is why I came up with a vacating.
That you'll suffer for some more time.
Yeah, may I request them, let them put whatever they want to, because now they say they have another bundle of documents. Let them put all that in by way of a supplementary. I'll deal with a composite. Because this is also not on affidavit. This letter which has been handed over to your lordship seeking the balance confirmation is also not on oath.
But I'm led by
part of the record.
Led by Mr. Bachawat.
Yes.
Just one sentence.
Yes,
Not this dispute that my learned friend is talking about, let's assume it's there. The point is not this law is well settled, but these can't form the subject matter of a dispute under 11. It has to be decided by the arbitrator. It's not within the scope of a section.
No,
and that's been decided in a matter.
Mr. Bachawat, what he is trying to say is that there is no agreement between the parties.
May I just indicate, Nada, that there is a finding on these very same agreements with regard to this SCFL, SIFL, not in your lordship's order under section 9, not challenged by them. Not three times the order has been extended. There is no opposition to that. Number one, your lordship's order stands. It says there is an arbitration agreement. Number two, my lord, the agreement itself says that, my lord, the respondent includes its assigns. So, my lord, I'm covered by that. Number 3, this has happened by operation of law by virtue of an order, not sanctioning a resolution plan. Now, these factors have also been considered by another judgment of our court, not in relation to the very same agreements. The court has said, look, these disputes have to be decided by the arbitrator. It cannot come within the scope of the Section 11 court. And this is based on 2 Supreme Court judgments.
As far as that submission of yours is concerned, that it can be decided by the arbitrator can only be in terms of the arbitration agreement.
Right.
If he is fundamentally questioning the arbitration agreement, that there is no
Lord,
agreement.
may I just give your lordship the principle, if your lordship doesn't mind, from the judgment? What it says, Lord, there is a difference between substantive existence of the arbitration agreement, not as opposed to a factual dispute. Not here, the substantive, not all that your lordship has perhaps not subject to correction. Not what the judgment says is your lordship only has to see
I'm with
whether.
you, Mr. Bachawat. I'm absolutely with you on that point. I mean, I've been holding it in almost all my judgments. I'm not
Not here, there
questioning.
is an arbitration agreement signed by him. He cannot dispute it.
That's what I'm saying. That's exactly what is disputing.
It's signed by him. He's not disputing that. He's not disputing the fact that he has signed the arbitration agreement. Signed by him. Signed by him is admitted. His signature appears.
Not with you. Yes. Not signed with you. That's what he's
It's
saying.
been assigned. Very well. But I leave it to your lordship. If your lordship wants to allow him to file affidavits,
I don't. If you ask me, I would rather refer it to the arbitrator to decide the entire. I can do nothing, honestly.
But in that case, let him make his submissions. I deal with.
Only
I'll
my
deal with.
time will be wasted, Mr. Bachawat.
Very well. Let him file.
My time will be wasted to the extent of deciding that issue. Because the assignee, I'm completely with you to the extent that if it has been assigned, then you have a right. There's an arbitration clause which exists between both the parties. And everything has to be decided by the arbitrator. I can't decide anything.
I'm obliged.
I have to send it. But if he's raising that technical ground, where he says that even you being the assignee, he doesn't have any privity of contract with you. Oh, that's with all due respect, Mr.
I'm saying he's not the
I
for this loan.
I do not appreciate that kind of argument at all, but you are entitled to make those submissions completely.
May I just say this? I say that this loan is not being assigned to him for 2 reasons. A, this loan agreement does not form in the
See, that issue we have already seen, and we have verified to the extent that they were maintaining 2 numbers.
There's nothing on fact to say this. With the greatest of respect, this document is not on record. If Mr. Bachawat doesn't want to bring this document on record, I am willing to argue this matter on the documents which are there. I'm very clear. Let this document not be taken on record. If he doesn't want, he has to affirm an oath that this is what it is, because this petition doesn't say this. He can't take the high ground that let me use an opposition to a document which is not on record. If he doesn't affirm his oath too, there is no mention either in the section.
But I'll file a supplement.
The section, yes.
But I'll file a supplement.
Yeah, we have
Yes,
now.
sure. You have
On
it.
the basis of the
Supplement.
9 and the 11, there is no case.
Of the section 9.
Lord, my learned friend says so. Lord, there's acknowledgement by him that the money is due to me. I can show that document here and now.
You file your supplementary
Very
affidavit, bring that on record.
No, on record. On record. Lord, please take the section 9. I'll show that. Lord, please take the section 9. Volume 3.
Volume 4.
4, sorry. Show me the first page.
Volume.
Lord, Annexure L begins at page 486.
Yes.
486 is not his auditor's report. Your Lordship has seen Aviral auditor's report. Now, Lord, please come to page 501.
Yes.
Lord, please have a look at. Your Lordship has got 501. Lord, notes.
Yes.
Just when I'm reading it, I have to.
Notes to the financial
Notes
statement.
to the financial statements for the year ended 31st March. Long-term borrowings, term loans from financial institutions is what it says. Now, Lord, the amount is given 44782. Now, Lord, please go to the bottom of the box. Secured by way of first charge on movable and immovable assets, both present future, on cash flow flows arising from borrower in the form of and manner acceptable to whom? SEFL. He acknowledged it in his balance sheet and also 508. In two places, he's acknowledged it. After that, Mr. Thakkar makes this not submission. Please see 508, 13.19. Who is the lender? He is talking about the lender. The lender, Shrey Equipment Finance Limited, SEFL. He's treating me as the lender. And after this, my learned friend makes the submission that this contract has not been assigned. The letter which I've handed up, he says he has never received it.
First page which you showed your lordship here.
Therefore, my lord, when my learned friend says not on record, it's there. There's an acknowledgement by him, which I showed earlier.
508, yes.
Yes.
13.19.
13.19. Lender SCFL through its administrator Rajnish Sharma has filed an application under section 66 of the IBC code before Kolkata. Application is numbered as so and so. So applicant SIFL has claimed an amount of so and so. Matter is pending in hearing. Next date of hearing is so and so. This is the IBC application which I have referred
Correct.
to. Now kindly see the IBC application. Kindly see the IBC application. I am just.
This is an acknowledgement by him.
This is the recording of what is a matter of fact what he has done. Now kindly see the IBC which is annexed to the section 9. Kindly have the IBC application once.
Page.
Yeah. Starts at
I have nowhere said this is not the lender. We have said that these transactions may be bad. The administrator said so. There is no order passed in it.
no, kindly I want to trouble you also once with the IBC application, fact of which is only recorded.
Page 1.
197. No. No, it's in the section 11. It's not in the 9. Can you have the section 11?
Section 64. Yes, section 11.
Page number.
I'll give you the page down.
Yeah.
Second one. Third one. Third volume. Third and fourth. Please give the third and third volume. Kindly say come to 446, please, madam. Is that shown your lordship, madam? What is the financial assets, etc.? I just want to show you lordship now the section 9. Can we have the fourth one? Yes.
Yeah, arguing on the matter, madam, there's no supplementary affidavit now which is coming, I understand. And we have 5 points.
We understood this.
Who is he arguing the matter? He's saying he doesn't want to use. You want to use the supplementary?
Yes, I said.
We are
I said.
wasting my lord's time.
Yeah.
Let the supplementary come.
I'll file those two letters. Not these they were given to him earlier. These were given to him earlier on the last. Do you have a supply? Do you have a supply? No. But I'll file a supplementary in a week. Not
You
1 week.
file your supplementary in which section 11 or 9? 11. 11.
And we can file an opposition to the vacating application as well.
Learned counsel for the petitioner seeks and is granted liberty to file supplementary affidavit. Bringing on record. Bringing on record.
Bringing on record letters, not two letters. Date bolna hai. The ones which you handed.
Bringing on record documents relating to the transaction
My
between the parties. Within a period of 2 weeks.
2 weeks.
They have it ready.
Affidavit ready.
Within a period of
opposition. Yeah.
And section 11, you want to file your affidavit in opposition.
I'll file a combined manner.
Petitioner has preferred the present petition under section 11 of the Arbitration and Conciliation Act, seeking appointment of an arbitrator to adjudicate the dispute between the parties in terms of clause 22.2 and clause 11.3 of the deed of hypothecation dated 21/1/2019. Full stop. Learned counsel for the respondent at the outset states that the present petition is not maintainable since the parties have not entered into any contract and thus he is not bound by the terms of the arbitration clause as contained in the agreement relied upon by the petitioner. Full stop. He seeks and is granted. In view of the same, he states that the present petition is not maintainable. He seeks and is granted. That's his submission. He seeks and is granted. How much time?
2 weeks from the date they file the supplement. 1 week from the date they file the supplement.
4 weeks time. 4 weeks time to file his affidavit in opposition. Reply to the same if any within 2 weeks thereafter. List after 8 weeks. All right. You want me to cut short?
You want to cut it short? We are happy.
Because
Then
4 weeks, but in effect, I don't.
if you file within 1 week your supplementary affidavit,
We'll file the supplementary
affidavit ka kar do, 2 weeks ki jagah 1 week kar do. I'll give you 3 weeks.
No, 3 weeks from
3 weeks for you
3 weeks from today.
from today. So 3 weeks to file his affidavit in opposition. Reply to the same if any within 1 week thereafter. List after 4 weeks.
obliged. But interim order is expiring today.
Yes,
No,
interim
sorry.
order.
Oh, sorry. 11. I'm sorry.
Item 9, section 9 में करना. Interim order. Interim order granted earlier is further extended for a period of. When is it expiring, Mr. Bachava?
Expiring 15th July.
15th July. Is extended further for a period of 8 weeks.
But may I file a?
All right.
Right.
आइए देखो.
ये number तो बोलो ना यार.
Learned counsel for the
IA number 1.
yes. GA counsel for the respondent has GA1 has been filed by the respondent seeking vacation of the interim order granted by this court by order dated so and so. Full stop. Learned counsel for the petitioner seeks and is granted.
For 1 week. Oh, they'll all come together.
2 weeks to file his affidavit in opposition. Reply to the same if any within 1 week thereafter. List after 4 weeks. Both the petition together.
Obliged.
Interim order ka date lena.
The original interim order was dated 6th January
Interim order dated 6th January
2026, my lord.
2026.
Grateful.
Thank you.
May it please your lordship. Lordship, this matter had come up on the last Wednesday, lordship. The lordship had directed us to reserve upon the respondents. We have done that. However, it has not reached yet. The matter has been, there is another matter, similarly connected matter, lordship, same petitioner, which has been fixed on this Wednesday, coming Wednesday, lordship.
All right, not today, keep it on Wednesday.
Grateful, lordship.
My lord, as per the instructions, my lord, from both parties, the negotiation is going on. Kindly adjourn for 3 weeks so that the negotiations can be settled.
Learned
That was my instruction from the petitioner.
Learned counsel for the parties submit that they are still exploring the possibility of an amicable settlement. They pray for an adjournment. Let this matter be adjourned to
3 weeks, my lord.
after 4 weeks.
Item 19.
Item 19, 20, and 21 are my Section 11 application. But my lord, one thing before, my lord, I'd like to, that possibly going by the specified value, it should have been filed in the non-commercial division. My lord, kindly direct this to be transferred to the non-commercial division, my lord. I just noticed because the claims are less than 3 lakhs, though recurring claim, but as on the date of filing, these are less than 3 lakhs. Section 11 applications.
Withdraw it and file it. Why should this always be transferred?
my lord, have been filed. Just in case, we'll do the necessary corrections, my lord, in the cost title, and if it can be, my lord will only be taking up these matters in the non-commercial division.
That's right.
It should have been filed in the non-commercial.
Withdraw it and file it on the non-commercial
If it's
side.
possible for my lord to direct a transfer, then my lord will do the necessary, all the necessary liberty be granted to carry out the necessary corrections in the cost title.
Learned counsel for the parties submit that the matter should have been filed on the commercial side, since the pecuniary value of the dispute is
Less than 3 lakhs.
3 lakhs. Full stop. Let this matter be transferred on the non-commercial side. The registry is directed to renumber the same and list it on the non-commercial side. Full stop. Within, after 3 weeks.
My learned friend will take the point when it. Yes, well, up to item 21, 19, 20, 21. 20 and 20. Yes, 19, 20 and 21.
All right.
Item 22.
Your petition. Come this side.
My lord, it is a dispute between two banks with regard to certain secured assets. Securitization issues are there between two banks. There is an earlier order of my lord Justice Mukherjee, my lord, perhaps my lord, but my lord, Justice Mukherjee, I just placed this judgment of Nangli's rice mill before Justice Mukherjee's last occasion, when my lord Justice Mukherjee was pleased to take up this matter. My lord Justice Mukherjee also referred to Vidya Drolia's case and the case of Booz Allen, whether these issues are arbitrable or not.
Yes, I'll just come back in 5 minutes.
My lord. No, my lord, so far as my humble understanding goes, subject to correction, my lord, the observation of my lord Justice Mukherjee has not laid down any law in that sense, my lord. It is a mere observation of my lord Justice Mukherjee. My lord, on the last occasion, I should have got that hard copy at near the order dated, my lord, may I, that is in the order sheet, my lord. If this matter was taken up earlier by my lord Justice Mukherjee, my lord. I should be very candid at the very first instance, my lord.
Yes.
My lord, first of all, my lord, I would like to clarify my fact, the fact of my case. First, my lord, it is a dispute with regard to securitization inter se between two banks, my lord. Two feeder banks, the State Bank of India and Canada Bank. My lord, it is not a dispute with regard to the mortgage. My lord, I do not want to go for an arbitration to seek an order of enforcement of the mortgage. Because enforcement of the mortgage is something else, my lord, which is between the bank or the financial institution, inter se bank, financial institution, and the borrower or the guarantor. But here, my lord, the arbitrator, the zone of arbitration is quite limited. It is the learned arbitrator is to find out whether X bank is having a prior interest or X bank is in a position, is a better position to seek for their right of enforcing the mortgage, or Y bank is having the right to seek for their enforcement of their mortgage. Who is in a better position to seek for the enforcement of their mortgage? It is the case.
Actually, Justice Mukherjee, has rightly pointed out that where the serious note of fraud is involved, in such case, arbitration applies. And here in the case, the mortgage is already involved. In such cases, Justice Mukherjee has rightly pointed out and questioned the very maintainability of this question.
Now let the arbitrator decide. Let the arbitrator decide.
Section 16, you have remedy.
Either you're disputing.
Very maintainability of the question, it is in question, and
The very maintainability, then you file your response if you're disputing this. Because I feel that it should be referred to arbitration. That is just a prima facie view of Justice Mukherjee. He has not concluded.
No.
then I prefer learned advocate Siddharth Lahiri for appointment of
My lord, I do not have any objection.
Both the parties agree, then
I do not have any objection. Learned Mukherjee, Siddhartha Lahiri may be appointed.
We'll jointly appoint Mr. Siddhartha Lahiri. The petitioner has preferred the present petition under section 11(6) of the Arbitration and Conciliation Act, seeking इसको नहीं 11(6) of the Arbitration and Conciliation Act, read with section 11, right? Section 11 of the Securitization.
Section 11.
Section 11 of the Securitization and Reconstruction of Financial Asset and Enforcement of Security Interest Act 2002, seeking appointment of arbitral tribunal to adjudicate the disputes that have arisen between the petitioner and the respondent in relation to the competing security interests claimed by the parties over two immovable properties prescribed in Schedule A and Schedule B of this petition. There are two properties, right?
Two properties.
The dispute concerns the validity and parity of the respective mortgage interest asserted by the parties over the two secured assets and the legality of the measures initiated by the respondent under the provisions of the Surface Act. Full stop. Learned counsel for the petitioner states that on 6 November 2021, the State Bank of India sanctioned a housing loan in favor of one Shri Abhijit Kar for purchase of flat number 303, block 3, third floor, situated in the project developed by Roofers Infrastructure India Private Limited. Full stop. According to the petitioner, the said borrower created a valid security interest in favor of the petitioners by depositing the title deeds relating to the said flats. Petitioner, petitioners. Respondents, said flat. Subsequently, the petitioners came to learn that the respondent bank had issued a demand notice under section 13(2) of the Surface Act dated 11th September 2024, alleging that the very same flat had earlier been sold in favor of Srimati Jayanti Sounth, Sounth, wife of the managing director of the developer, who had obtained financial assistance from the respondent bank in January 2020 and had defaulted in repayment. Full stop. Consequent thereto, the respondent bank also issued a possession notice under section 13(4) of the Surface Act dated 21st January 2025. The petitioners allege that the transfer in favor of Srimati Jayanti Sounth was fraudulent, collusive, and engineered only to create a competing mortgage in favor of the respondent bank. The petitioners further contend that they had sanctioned another housing loan on 20th December 2019 in favor of Pankaj Kumar Singh for flat number 103, block F, first floor, which had originally been purchased by the vendor from the same developer. Full stop. According to the petitioners, they subsequently discovered that the said property had been fraudulently transferred in favor of one Prashanta Biswas, the brother-in-law of the managing director of the developer, who had allegedly obtained financial assistance from the respondent bank in January 2020 by creating a mortgage over the said property. Full stop. The respondent bank thereafter issued a demand notice under section 13(2) of the SURFACE Act on 11th September 2024, followed by a possession notice under Section 13(4) of the SURFACE Act dated 21st January 2025 in respect of the said flat as well. According to the counsel for the petitioners, both the original borrowers financed by the State Bank of India continue to remain in possession of their respective flats, and the mortgages created in favor of the respondent bank are invalid, illegal, and incapable of prevailing over the prior security interests created in favor of the petitioners. Full stop. It is alleged that the respondent bank had proceeded on the basis of fraudulent transactions brought about in collusion with the developer and its related persons. Learned counsel for the petitioner contends that in view of Section 11 of the SURFACE Act, disputes between the banking institution relating to securitization, reconstruction, or non-payment are required to be resolved through arbitration or conciliation. Full stop. Accordingly, the petitioner issued a notice dated 27th April 2026 invoking arbitration under Section 21 of the Act, proposing the name of Mohit Gupta as the sole arbitrator. Mohit Gupta, advocate, as the sole arbitrator. Full stop. The said notice was admittedly received by the respondent on 9th April 2026. Full stop. However, the respondents failed to take any steps or invoke or appoint any arbitrator in terms of the said notice. Instead, full stop. Instead, the respondents proceeded with the SURFACE measure and issued legal notice scheduling auction of both the properties on 24th June 2026. Learned counsel for the petitioners submits that the dispute squarely falls within the ambit of Section 11 of the SURFACE Act, and in view of the law declared by the Honorable Supreme Court, the existence of a statutory arbitration mechanism is sufficient for the purpose of exercising jurisdiction under Section 11 of the Arbitration and Conciliation Act 1996. He further submits that the respondent failed to act upon the notice invoking arbitration, thus making it a fit case for appointment of an arbitrator. Learned counsel for the respondent does not oppose the said contention and consents to the appointment of an arbitrator. Full stop. The parties jointly suggests the name of Mr. Siddharth Lahiri, advocate, to act as the sole arbitrator to adjudicate the dispute between the parties. The learned arbitrator shall enter reference in due compliance with Section 12(5) of the Arbitration and Conciliation Act 1996. Full stop. The learned arbitrator shall be entitled to remuneration in terms of the fourth schedule of the said act. Full stop. A copy of this order shall be communicated to the learned arbitrator to take necessary steps. Full stop. The learned arbitrator, with the aforesaid direction, the present petition stands disposed of.
An interim order may be granted. Otherwise, they have already started proceeding under SURFACE Act. They will sell the properties.
After 11, I'm not going to grant any interim order. What are you saying? You go before the arbitrator. Why should I grant you any interim order? File a Section 16. There's no question of me granting an interim order at this stage, sir. I've appointed the arbitrator, approach him. As soon as possible, get an interim order for the auction, stay of the auction.
Right.
All the issues relating to arbitrability, maintainability, etc. will be.
My lord, the affidavit of service may be kept.
Affidavit of service filed by the petitioner is taken on record.
I appear on behalf of the petitioner, Lordship. Lordship, I'm seeking some time. I've yet to receive some instructions from my client. Kindly keeps it after 7 days. I'll come back, Lordship.
Not opposing the appointment of arbitrator.
Lordship, I know. Lordship, I have not received instructions, Lordship.
You have not received your fees or instruction.
Lordship, I would say both. Obliged, Lordship.
Yes.
24.
May I have the privilege to address on behalf of the petitioner? There is a, please. Oh. As it may be convenient, Your Lordship, I would be always ready.
All right.
My lord,
Wednesday.
service may be kept with the record.
What's the point?
No, because I tell you, Lordship,
All right.
there are two address. One is refused, other is intimation served but not claimed. And they have. So I do not know whether tomorrow, my lord, nobody appears.
Affidavit of service taken on record. Proxy counsel Ms. Shijani Mukherjee states at the main arguing counsel, Mr. Amrita Mandal. Amritam Mandal is in some personal difficulty. She prays for an adjournment. Let this matter be listed on Wednesday.
Extremely grateful. Deeply obliged.
Twenty-five.
This is my section 11 application.
I'm instructed to appear with my book alert number notice and another obligation, another documents which I referred to before. Not yet. I will keep it on Wednesday.
Not today.
Yes.
I appear for the petitioner, Your Lordship. It's a section 11 application.
Who's on the other side?
Last occasion, Your Lordship, she had appeared on VC, Your Lordship. He'll appear in the last order, Your Lordship.
They're disputing. Are they disputing?
Yes, Your Lordship. Affidavit service I filed, Your Lordship. Last occasion. Lordship may kindly takes up page.
We'll have it on Wednesday. Nobody's here.
Your Lordship, I'm just seeking for an appointment of arbitrator.
I know.
What had happened, Your Lordship, was we had filed a suit. They filed a section 8 application there. My suit got dismissed. They said that this is a dispute regarding arbitration. We go for arbitration. Subsequently, I made multiple letters to them. You appoint an arbitrator. They have not done anything of that, so that's why I've come before Your Lordship.
Wednesday. Not today. Inform them.
Your Lordship, the issue is I could not find her because she's only appeared online and there is only her name there.
The name is there.
From there, I cannot because I think she's very young in practice, maybe 1 year or 2 years. I cannot detect where she is.
We'll see that.
Lordship, this is my section 11 application.
Point of jurisdiction.
It's in Delhi, Lordship. Lordship, everything has happened here otherwise, but exclusive Lordship, I'll come back with instruction. Lordship keeps it on Monday. Both 27 and 28, Lordship. Grateful. 35 as well, same.
So 27,
28,
and
35.
All three matters on Monday.
Great.
Different party, but the same.
Issue is the same.
Issue is the same.
Respondent is the same.
Grateful, Lordship.
All three will go.
Look that out. So grateful.
Adjournment 29.
Lordship, this is my section 11 application.
Yes,
We have served, but it has returned to the sender specifying insufficient address.
Find the address and serve them again. Learned counsel for the petitioner seeks and is granted liberty to serve upon the respondent within a period of 2 weeks, 3 weeks.
3 weeks.
3 weeks, list after 4 weeks. Same. 30 same.
No, Lordship, it has been delivered to respondent number 1, but for the respondent number 2, it is being returned as insufficient.
Learned counsel for the petitioner states that the respondent number 1 has been served. Affidavit of service. Affidavit of service taken on record. Affidavit of service indicates that the respondent number 1 has been served. Learned counsel
Lordship,
for
a
the
notice of
petitioner
motion.
seeks and is granted liberty to serve upon the respondent number 2 within a period of 2 weeks. That this matter be listed. 2 weeks or 3 weeks?
3 weeks.
3 weeks, list after 4 weeks. How many respondents? 2. 1 has been served, 2 service. Thirty-one.
Lordship, when the service is complete on both the respondents. A notice of motion.
What are you seeking? 11. Appointment.
Yes, Lordship. Yes.
Arbitrator. Causes. Agreement dated
Agreement dated, Lordship, August 16, 2020.
August 16th. 16th August 2020. Clause
23. Page 31.
agreement starts from page 13.
Yes, Lordship.
This is loan facility.
Loan cum hypothecation.
Clause on page
Page 31, Lordship. Where's the arbitration clause? Lordship, 23, clause 23, page 31.
Where's the venue?
Lordship, as per clause 24.2, it is in the loan cum hypothecation schedule at page 39 and B5.
Mentioned in the schedule. Where's the schedule mentions the
Page
place?
39, Lordship. Clause B5. Calcutta.
What is the amount?
Lordship, the claim amount is 1 crore.
The notice, recall notice.
Recall notice is Annexure D, Lordship. At page
Connection, page.
76.
Twenty-one notice.
Lordship, at page 82.
All right, take that. The petitioner has preferred the present petition under section 11(6) of the Arbitration and Conciliation Act, seeking appointment of a sole arbitrator to adjudicate the dispute and dispute between the parties arising out of a loan facility agreement dated 16/8/2020. Just listen to the order, madam. If there's any correction, tell me. 16/8/2020. That's the agreement date. Learned counsel for the petitioner states that a credit facility was advanced to the respondent for purchase of a
Excavator.
hydraulic crawler excavator to the tune of rupees 348,500 to be repaid in 48 installments as per the agreement dated 16/8/2020. Learned counsel for the petitioner submits that the respondent defaulted in the repayment of the said loan facility advanced by the petitioner. Full stop. Demand from recall notice was issued on 31/5/2024, wherein the petitioner sought a sum of rupees 6522790.04 as the amount due on 29/2/2024 to be repaid by the respondent. Full stop. Did he respond? The respondent did not respond to the said demand come recall notice. Full stop. Leading to the issuance of notice under section 21 for invoking the arbitration clause as contained in the agreement dated 16/8/2020. Full stop. Despite receipt of the said notice, the respondent did not take any steps for appointment of the arbitrator or constitution of the arbitral tribunal. Full stop. It is prima facie evident that the respondent had taken the loan facility in terms of the agreement dated so and so, dated 16/8/2020, full stop. It is the said loan, the respondent defaulted in payment of the said loan, leading to the issuance of the demand notice as well as the notice invoking the arbitration clause, the arbitration, full stop. The scope of section 11 is limited to the extent that the court has to be satisfied that a valid arbitration agreement exists between the parties containing an arbitration clause, full stop. This court is of the view that in the present matter, the perusal of the documents and the argument advanced by the petitioner establishes the fact that a valid arbitration agreement exists between the parties and that a dispute has arisen in terms of non-payment of the loan advanced by the petitioner to the respondent, full stop. In view of the same, it's a fit case for appointment of an arbitrator. This court appoints, how much is the amount? 64 lakhs.
No, Lordship, 1,05,20,637 is the same amount as on 31st May 26.
How many years you have put in? How many years you have put in? No, you. This court appoints Mr. So and so. What's your name?
Rajashri Bhatt.
Rajashri Datto. Mr. Rajashri, give your details. Mr.
Phone number.
So and so as the sole arbitrator to adjudicate the dispute between the parties. The learned arbitrator shall enter reference in due compliance with section 12(5) of the said act. He shall be entitled to remuneration in terms of the fourth schedule of the said act. A copy of this order shall be communicated to the learned arbitrator to take necessary steps, full stop. With the aforesaid direction, the present petition stands disposed. Affidavit of service taken on record.
Law 32.
In this service was refused by respondent number 1 and delivered upon respondent number 2.
Affidavit of service taken on record. The service report indicates that the respondent number 1 has refused service with affidavit of service taken on record. The service report indicates that the respondent number 1 has refused service. Refusal of service is good service, full stop. The respondent number 2 has already been served, full stop. सेम होगा इसमें, आप इसमें से चेंजेस करो. Date of the loan agreement will be
15 January 2020.
What is the date?
15 January 2020.
15th January 2020.
Yes.
What is the demand date?
Demand notice dated 31st May 2024.
31st
May 2024.
2024. And section 21?
8 June 2024.
8 June 2024. Amount?
Claim amount is Lordship 1,38.
Page. Demand notice. Show me the demand notice.
Demand notice is at page 75.
Page 75 से ये आप page 75 से agreement date मिल जाएगा. All right, I'm marking it. Amount is right here. All right, this is the amount which is the loan amount. All right, Today the due amount is this much. ये 3 मैंने mark किया. This one is the due amount. All right. If, Mr. What's your name? Shobik? Mr. So and so is appointed as the sole arbitrator. Give your details. Yes.
Lordship, in the service is not complete. It
Learned
came
counsel
back
for the
with
petitioner seeks and is granted liberty to serve upon the respondent within 2 weeks. Within 3 weeks. Seeks and is granted 3 weeks time to effect service upon the respondents. List after 4 weeks. Affidavit of service taken.
and notice of motion.
Item 34.
I am appearing of the petition, I am praying for not today.
Not today.
Yes.
Yes.
35. Sorry, 36.
Yes, sir.
My affidavit of service, man. Earlier the matter was.
Yes, he's saying something. Yes.
My lord, actually, that matter was filed as AP.
My lord, the order is at page. My lord's order is at page. Is at page 67. My lord's order.
My lord.
Yes.
My lord.
Respondent number
My lord had granted liberty to file a issue a phrase section 21 notice and file a phrase.
What I am. My lord, the respondent number 1 undoubtedly established, but I am not I did not prepare the regarding I am kindly allow to submit
Submit what? Submit what? You are Mr. Boral. You are Mr. Boral.
Yes.
What did you do?
My lord, last occasion when the matter was taken up.
Yes. What did you do to her?
My lord, I was submitting that when my lord was dictating the order, I told my lord to look after to take cognizance of the section 40.
Don't do that. All right.
My lord's order. Thereafter, section 21 notice has been served. Is at page 73. My lord, annexed F.
And granted you liberty to serve upon section. Yes.
My lord, no.
What is the difficulty? What are you opposing?
My lord, actually similar matter.
Not similar matter. I had given him. Which is the similar matter? This one. This is not dismissed. I gave him liberty to issue section 21 notice.
Allow me another.
If you are saying that this, sorry?
Under auditor, the respondents stay and or permanent judges.
Sir, this is section 11. Section 11 has to be filed here.
I am not. I am submitting.
You can't enter into that. This section 11. Only I have the right to appoint arbitrator. This is not 2-1 court for this purpose. No need for response. I don't need your response. You argue whatever you have to argue. I'll deal with your contention. You have not given a service.
Service has been effected.
That is served, undoubtedly that is served through the respondent, the application of it.
So you come next week. Next week.
That's why I'm.
Not today, next week. Next week.
Monday.
Next Wednesday.
$37.
I appear for the petition. And this is my affidavit of service.
Any objection?
Only the arbitration clause contained one of the entire mechanism that it should.
Forget about it. Now he has filed 11.
That was the only objection at the 11th stage. I have no other objection. And my lord, it's an unregistered, my lord, unstamped document which I have, my lord, the liberty to take before the arbitration.
Yes, he'll get it impounded and stamped or whatever he has to do.
At the relevant stage.
The relevant stage. Monday.
Lordship.
All right. Rest of the matters Monday.